I don't know if we're live yet, but hey there. All right, looks like we're live. We've been live for 6 seconds, and it's just been scrolling or clocking on my side. So hey, good morning, y'all. I'm gonna just give it a second, let people get notified that I've gone live. I haven't gone live in a long time, so this is the first of many, hopefully, and we're going to talk this morning about some business and tax topics at 11 a.m. on a Saturday morning Central Time. If you're watching this live, if you're not watching it live, then it's whatever time it is where you are. Obviously, you're welcome for that tidbit of information there. So, all right, let's get into it. So, let's see, where are my notes? There they are. So, we're going to talk about some basic entity types. I know a lot of people have, LLCs. If you have a small business, you probably have an LLC. I do still see some corporations, and people form those, for various reasons. You also see partnerships. Most of them are limited partnerships. Most of the small business corporations nowadays are taxed as S corporations, and that's good. That's good. We'll get into the differences between the various entity types, why S corps are good for small businesses, why LLCs are also good for small businesses, and then how to combine those for maximum impact. So the first entity type that we're going to cover this morning is the partnership. It is probably the oldest, or not probably, it is the oldest form of business. I guess you could call it an entity, but a partnership, at least under Texas law, is technically a business entity. So the very simplest form of a partnership is a general partnership, where two or more individuals come together, work together for a business purpose. All right, and that is the common law, I guess, definition of a general partnership or a partnership. With a general partnership, there's basically no asset protection. So if one of the partners gets sued, or if the partnership gets sued, then all of the partners' personal assets are on the table for satisfying whatever liabilities there are. So we tend to avoid those for that reason. The limited partnership is a different type of partnership. It is a creature of statute. So there's no just common law limited partnership. You have to actually file something with the Secretary of State to create one. And the way that works is there are two types of partners in a limited partnership. There are the general partners, there's usually one general partner, but you can have more than one, I suppose. And then there are limited partners. The limited partners are going to have, surprise, limited liability. All right, you probably knew that. It's kind of in the name, right? The general partners, if there's more than one partners, usually we have one, but they're going to have unlimited liability. So that's why many times you'll see in a limited partnership, the general partner is actually an entity, like a corporation or an LLC or even a trust. And that limits the liability of whoever it is that's actually running the day-to-day operations of the business. So you generally have a person, a manager, an operations, chief operations officer, whatever you want to call them, the general partner individual. And it takes humans to actually run the business, right? But they want limited liability. They want to limit their liability. So the way we do that is to make them the manager of an LLC that is actually the general partner, or the CEO of a corporation or president of a corporation that is the general partner of that limited partnership. So that gets kind of complicated. The simplest way to do that probably is either with an LLC or a trust as the general partner. The next type of partnership is a limited liability partnership. We don't see these very often with most businesses, but they are useful for businesses where all of the partners want to be involved in the day-to-day operations and management of the company. We see them a lot of times with law firms or other professional types of firms, and that's because all of the partners have a say, and they also have equity. It does, so all the partners are limited partners, and they all have limited liability, and they all have a say in the day-to-day operations. So those are the important points for the limited liability partnership. And then, the last one that we'll cover there briefly is the limited liability limited partnership. So That's the newest form of partnership. It's not even recognized in every state. Probably about 30 or 35 states have this. It is a limited partnership, but the general partners have limited liability. The most common use is for real estate investment. And an interesting factoid, CNN is actually organized as a limited liability, limited partnership. Any kind of partnership is going to file a tax return on a Form 1065, just for your information there. All right, I think that's enough about partnerships. I need to drink of water. All right, and if you've got questions about any of this stuff as we go along, I'll check periodically if there are questions in the comments, and I'll answer those questions as we roll along. So the next type of entity that we're going to talk about is the corporation. Corporation. There are two types of corporations in the United States. There's the C corporation and the S corporation. We're going to talk about both. So the C corporation is authorized under the tax code, subchapter C. It's actually 26 U.S. Code, subtitle A, chapter 1, subchapter C. So in case you were curious about that, it is the default type of corporation. So when you form a corporation, if you don't elect S corporation status, then the default is going to be C corporation. Every corporation has shareholders. They are the owners of the company. They elect a slate, or they elect a slate of directors. So they either just appoint them if there's one shareholder, then in a small corporation they're going to usually elect themselves as the director and the president and so forth. But in a larger corporation, you'll have a shareholders meeting every year, or if it's a new corporation, then they'll have an initial meeting of the shareholders. The shareholders will consider a slate of directors. Sometimes there are, it's not just, acclamation, or sometimes it is competitive. Most of the time it is not. But they will choose the directors, and they do that by voting. And then the directors will appoint officers. Now, in every corporation, there are required officer positions: president, secretary, and treasurer. The president obviously is the chief executive, responsible for the management and operations of the company, and ultimately bears responsibility for the success or the failure of the company. The secretary, not the person who answers the phone, not like you see, but this person has a lot of responsibility. They're responsible for all of the documentation, making sure that the records are kept properly. So if there's a decision that's made by the board of directors or by the company, then the secretary is responsible for maintaining those records. They're responsible for maintaining the minutes and the books and all of that stuff. And then the treasurer, who is obviously responsible for the financial management of the company. C corporations are subject to double taxation. You've probably heard this, but they're taxed at the corporate level, and then they're taxed at the shareholder level when those shareholders receive distributions. Corporations file their taxes on Form 1120, and then that's a C corporation. An S corporation files on an 1120S. So, and then moving on to S corporations, like I mentioned, you have to elect S corporation treatment. It has the same management structure as a C corporation, unless it elects under state law to do something different. Many states have provisions that will allow a more streamlined management structure than a typical corporation. I know Texas does. The important thing to know about S corporations is that they have pass-through taxation, meaning income is taxed one time, and it's taxed at the shareholder level. So, and this presents small businesses with greater flexibility, greater opportunities to control their tax liability than they would if they, stayed with the C corporation. And that's going to be important when we talk about things like self-employment tax. So the reason that a lot of small businesses elect S corporation tax treatment is because you can limit the amount of self-employment tax that you pay. And what I mean by that is, um, if you are not, for example, sole proprietor, if you're organized, if or really not organized, you're just doing business as a sole proprietor. Maybe you have an assumed name certificate, a DBA that you filed with the state or with the county, and you're just operating your business, and it's everything is under your personal name, DBA, XYZ company. So when it comes tax time, you're going to pay self-employment tax on all of your all of your taxable income, right? So what that means is there's an additional about 15.3% tax that you're paying as a sole proprietor, um, because it's all taxable income as under your sole proprietor. That's under if you're filing on a Schedule C for the business income, it's all subject to that self-employment tax. Whereas if you were to organize as an S corporation, uh, then you could pay yourself a salary, and only the salary would be subject to that self-employment tax. And then any profits, any distributions from the company above over and above that salary would be characterized as profits, and you don't pay the self-employment tax on those profits, right? So it makes a lot of sense if you've been in business for a while and your company is profitable and you've got some excess income um, from the business, then it may be time to organize, restructure, organize elect S corp treatment, or file as an S corp. And I'll get into why it may not be a good idea to just form a corporation and elect S corp tax treatment in a moment. There may be a better way, and in my opinion, there is. And that's, I guess, that leads us into the next topic, which is limited liability companies, LLCs. Everybody's got an LLC these days, it seems like, but it's good. So the LLC combines the liability features or liability protection features of corporation with your choice of tax treatment. So you can either be taxed as if it's a single owner, if you're the only owner, then it's going to be taxed by default, kind of as a disregarded entity. If there are more than one owners, then it can be taxed as a partnership. Or you can elect corporation tax treatment, either C corp or S corp. Most small business these days are advised to elect S corporation tax treatment for the reasons that we talked about, and the reason that you might want to consider filing as an LLC versus a corporation and then electing S corp tax treatment is that LLCs, in my opinion, have superior asset protection to corporations. And the reason that I say that is because, for example, if you were to have a personal liability, for example, I said, for example, about 3 times there, but let's say your child has their driver's license, and they've had it for a year or so or whatever, and they have an at-fault accident, and the person on the other side of that accident, becomes a plaintiff, and they decide they're going to sue you for their damages, and that includes maybe some personal injury type stuff, and they want to be compensated over and above what your liability insurance pays. They find out that you've got a business, and this would have to be a pretty catastrophic accident, but it does happen, and so if what they're suing you for is over and above what your liability insurance will cover, then they may go after your personal assets. And if you have a corporation, then shares of stock in your corporation are personal property. And so if your plaintiff gets a judgment against you, and then they get what's called a turnover order, the court could order you to turn over the shares in your company. They could liquidate that company to satisfy the judgment. Now, on the other hand, if you have an LLC rather than a corporation, and your LLC is structured properly, you've got an operating agreement that has the right provisions in it, then you can elect charging order only protection, which means that your membership interest in your LLC is not personal property, and it cannot be seized by a receiver under a turnover order And so the best that the plaintiff is going to be able to do is put a lien on distributions from the LLC. That's still bad, but it's not as bad as them coming in and taking your company and liquidating it. And there are strategies to make that less painful. So anyway, that is my opinion on why being organized as an LLC and taxed as an S corporation is superior to just filing as a corporation and electing S corp tax treatment. There you have it. If you have questions about that, please feel free to let me know in the comments. I don't see any at the moment. We've been going for about 15 minutes, and let's keep rolling. I know this is riveting stuff. Yeah, so some common mistakes that I have seen are that you're working in the business, but you're only taking profit distributions and you're not paying yourself a reasonable salary, but you're organized as an S corp. So that's a big red flag. It may get you audited. The IRS regulations require that if you are taxed as an S corp and you're working in the business, that you have to be paying yourself a reasonable salary. Okay, another mistake that I see is you're paying yourself a salary that is too high. If you have an S corp, you really should want that number to be as low as possible so that you can eliminate as much of the self-employment tax as you can. So this won't get you audited, probably, paying yourself too high a salary, paying too much in taxes. Yeah, that's really not a red flag with the IRS. They like it. But it will guarantee that you're overpaying taxes, which is bad for you. So you should set your salary at a reasonable amount for your profession, not so large that you're paying more in self-employment tax than is necessary. All right. So, and there are other things that we could talk about, but that's really all I've got for you this morning. I know that's a lot. If you have questions, bottom line is I think LLCs are superior to corporations for asset protection purposes. And if you're a small business, it may make sense for you to be taxed as an S corporation so that you can minimize those self-employment taxes. And that's really the bottom line here is you want to maximize your asset protection, minimize your tax liability. And that's the baseline way of how we do it. There are other things that we can do, but that's really beyond the scope of this session. We can talk about that later. All right. If you have questions, reach out. You can call us 832-360-1165. If you're in Texas, if you're not in Texas, seek someone who is a professional in your locale. So to speak, and always get professional advice before you take any action. As well, this is not legal or tax advice, just for informational purposes, so that you can be better informed. And there you have it. So hope you all have a great Saturday, and I will try and figure out how to turn this off. Okay, there we go. See you soon.